And at this time, the court was going to allow counsel to argue his brief and then response from Attorney Powell just for completion purposes of a record. So I'm going to take testimony from you all, and then the court is going to proceed with its decision and determine if the hearing is going to proceed today. So since we are already somewhat familiar with it, I'm going to give you all 10 minutes aside and then make a decision, and we'll proceed from there. Is that fair? Or you know what, Miss Attorney Chide, I know you have somewhere to be at a certain time. Is there any objection from you, Attorney Franklin, or Attorney Powell, for argument to be 5 minutes?
No objections from the state judge.
No objection, Judge.
Attorney Chide?
Absolutely no objection.
Okay. All right. So you may proceed at this time.
Judge, I'll ask the court to take judicial notice of the brief that we filed, as well as the brief that was filed by the Office of Attorney General.
Okay, so the court takes judicial notice of all contents of the court's file. As of today, the court does not, the court's file does not reflect the brief filed by the Attorney General, but once it is on file, the court will take judicial notice of it.
Thank you, Judge. Judge, just a couple of things. Again, we did extensive research on this, and to our knowledge, and I stand to be corrected with facts or with authority, there is no, to our knowledge, at least based on our research, there is no legislative carve out for the Office of Attorney General when it comes to the interpretation of the provision for 157.002. The court is right, at least again from our research, in saying that this would be a case of first impression for the Dallas district. But this case has been heard, or this same issue has been decided in Houston, and I believe generally in San Antonio. So there is strong persuasive authority. And the case that we have in our brief, the Ray Lube case, so in Ray Mark D. Lube, and the citation for that is 404 SW3D 589, Karma 594. And it's a 2010 First District case out of Houston. And this very issue was argued, and the Court of Appeal in Houston, did not find that persuasive. And even in that hearing as well, the Court of Appeal in Houston cited to the ex parte Jimenez case, which is a San Antonio case, and the site for that is 737 SW2D 358360. And so in order to interpret the statute, which says that that you can add the financial activity record, otherwise would make nonsense of that statute, because then when can you apply that? So there is nothing in the family code that we can see, or any case that says that there's an exception for the OAG. So our position is he had notice. If he had notice, he knew he was being accused of not paying child support, and when he was accused of not paying the child support. And so any other thing now is nothing but gamesmanship and an attempt to try to hide or run away from liability. So we briefed this extensively with cites to authorities, and we asked the courts to put that all take that all into consideration.
Thank you so much, counsel. Attorney Powell?
Yes, Judge, thank you. Judge, I look at the plain language of the law and apply it to the motion. Again, there's two issues. There's the issue of the contents of the motion, and there's the issue of proof at trial. And we haven't had the trial yet, so we're talking about the motion itself. And if I may share my screen, Judge, just so I could just point out the specific provisions in the motion.
Yes, go ahead.
Let's see. All right, Judge, I have my screen up, and this is the motion for enforcement that's before the court. And what's in the movement's motion, the movements, they carved out specific time period that they are seeking to hold my client in contempt. They point out June 30th, I'll say July 2024 through November of 2024. And they attach the complete pay record from the Attorney General's office. I think that, so if, you know, their motion is different from the way the Attorney General pleads. The Attorney General doesn't put like one specific violation section and then attach the FINA. The Attorney General just attaches the FINA. Here, they want to focus in on specific dates, and it could be a reason for that. The reason could be maybe they know that they can't find him in contempt for other dates, so let's not plead those dates. Let's just plead this specific time period. And one concept of the law that I kind of always understood is that the specific outweighs the general. Like if you focus in on something specific, I think that outweighs the general. I look at the FINA as kind of general because that's the whole life of the case. But when you plead these specific dates, that's what my client is going to look at. And by pleading these specific dates, you have to follow the letter of the law. And the letter of the law is simple. 157.002 contents of a motion says that you have to plead the amount due and the amount paid, if any. And again, in their specific dates they plead, they don't plead the amount paid, if any. And I think what they're trying to argue is that the FINA can cover up the error. But again, that's not the point of the attached pay record. Remember in 157.002, it says that you may include as an attachment a copy of a record of the child support payments maintained by the Title 4D registry. And again, what was argued last time was that you could go to 157.162. But 157.002, when it talks about may include as an attachment a copy of the pay record, it doesn't tell you why you may include it. But if you look at 157.162, it explains why. It says that it's admissible to prove. The pay record is admissible to prove, to prove at trial, to prove at the hearing. It's not admissible as a substitute to fix errors in the motion, error in the pleading. So again, and as I understand, this is an issue of first impression, meaning that there's no rulings on this issue. So my client's position is that since these specific dates were pled and there's no amount due, then he doesn't have notice based on 157.002 of what they seek to hold him in contempt for, Josh.
Thank you, counsel. Attorney Franklin, if anything.
Yes, Judge. Just briefly, because the OAG did brief the matter. I know the court doesn't have it, but our position is very narrow, just specifically pertaining to the payment record, which can be attached to the pleadings for an enforcement action. We do agree with the reading of 157.002. Our pleadings being allowed to be attached in conjunction with any enforcement pleadings that would allege the violation that they are seeking to enforce, the manner that it was not in compliance, meaning showing that the payment was not paid, in the specific dates and amounts that payments were made, as well as any amount of accrued interest that occurred on the case. If all of that is included in a petition, as well as our payment record being attached to it. For that specific narrow reason, the OAG does agree to our petitions being included in any enforcement actions. We believe that it does satisfy that requirement, Judge. But again, it's just the very narrow issue as far as our pleading being included. That's just our argument, Judge.
Thank you.
If I may just, do I have any time left to?
Yes, counsel, you may proceed.
Okay, so real quick, the only thing I will point the court to is, again, as the court is well aware, there's mandatory authority and there's persuasive authority, and that there is persuasive authority. The second point, I think we made that, but we just want to amplify, is that we incorporated the financial activity record. So we believe that we satisfy the requirements of the code, and we take exception that the pleading or the motion was not, did not give him notice.
We didn't catch the end of what you said, counsel.
Our position, we incorporated the financial activity record, and it is settled law that if you incorporate something by reference, it's part of the pleading. So to the extent they are arguing that because we incorporated it is not part of the pleading, we think that is not a persuasive or it lacks legal merit.
Okay. Thank you, counsel. All right. So at this time, the court is going to deny the motion for judgment that was pending before the court on last time. The court is going to deny the motion for judgment and take testimony on the motion for enforcement. All right, Attorney Chide, you may call your first witness.
Okay. I'm confused. You said deny the motion, the objection to our motion.
Correct. The motion for judgment. He actually said a motion for directed verdict, but because it's a bench trial, it'll be a motion for judgment. So the court is denying that at this time.
Thank you, Judge.
You're welcome.
All right. At this time, the movement calls Mr. Usman.
Okay.
Judge, if I may, how much time will be is each side getting?
So typically you all, because this is a 30-minute hearing, you would get 10 minutes aside. Now, if you all want me to, if you want it to be less time, because I know Mr. Chide is on the time crunch, I don't know what you all want, what you all would like to do with that. Because now we're just going to proceed strictly on the motion itself.
Yeah. Maybe 8 minutes aside.
Everybody has to agree to that. Everybody has to agree to that. I can't give you 8 and not give Mr. Powell his 10 if that's what he would like. It's really up to you all. The AG, I will say this, not to throw the AG under the bus, but they typically have time left over, and they will usually give it to both sides, and I split it equally. It's however you all would like to do it.
And yes, Judge, I'm okay with that because I know ours is usually pretty quick if they need more time.
Okay. Attorney Powell?
I mean, Judge, I can't, if they're asking for a jail sentence for my client, and I don't know if I could have a trial regarding my client's freedom, and I only have 8 minutes to defend him.
Okay, that's fine. So we'll go with 10 minutes. Just so we liberate the issue.
Yeah, so I mean, because it's a 30-minute hearing, so and it's 3
Okay.
sides. So it's 10 minutes aside. However, like I stated, Attorney Franklin, she can give both sides her time if she would like to do that. And usually that's what they typically do because they have time left over.
Okay.
Okay, you may proceed.
All right. Mr. Usman.
Yes, sir.
Okay, you realize you're under oath, right?
Yes, sir.
All right. So you all know that this court entered an order establishing parent-child relationship between you and your children. Is that correct?
Yes, sir.
Judge, before,
Yes,
Judge,
go
can
ahead.
can he be, I
Admonish.
guess, can my client be made aware that he has the right to not testify?
Well, that's what you do.
Yeah.
Did you need to have that conversation with him?
Well, yeah, I would, yes, Judge, I would like to. I mean, I understand No, okay. All right. I'll talk to him.
Okay, I guess the court is confused. You ain't talked to him already about this?
Yeah, we did. Yeah, I know a lot of times, I don't know. I mean, he's using him to prove his case, prove his enforcement. I mean, that's a little different. You know, I mean, mom is the witness.
Well, he can call any witnesses that he chooses to call to prove his case, and he can do it. He doesn't have to do it in any particular order.
Yeah, I understand.
Your Honor, this is not coming out of my time, right?
No.
Thank you.
I don't know. I mean, I guess sometimes I have the. Okay. Yeah. Can I just talk to my client, Josh?
Okay. He put you in a breakout room real quick. Oops. Delete. All right. So I'm sending you and your client over there, Attorney Powell. Did you get it?
I did.
Hold on. There it is. Room 1. You get it now? And Mr. Usman, you should have it too. Okay, the court will be right back. Okay. Yes, we're back on the record.
All right. He could call him.
Okay. All right. Counsel, your last question was. So you know this court entered an order establishing the parent-child relationship between you and your children. Is that correct? So, Mr. Usman, you can answer that question.
Yes, ma'am.
Okay. And that is what is already been pre-admitted as our Exhibit 1, right? And you know that order ordered you to make payments for child support and medical support on your child. Is that correct? On your children, is that correct?
Yes, sir.
Okay. And so on July 1 of 2024, you did not make child support payment for your children of $824. Is that correct?
I have to look at I have to go back and look, sir. If I'm trying to think, I don't think I had a fight at that time. So
Objection,
no,
non-responsive.
sir.
Sustain. And sustain to everything before no, sir.
All right. So on July 1, 2024, you did not make a payment of $824 in child support as ordered by this court. Yes or no?
Yes, sir.
On July 1 of 2024, you did not make medical support payment of $250 as ordered by this court. Is that correct?
Not that I'm aware of, sir.
Okay. I'm confused. The last time you said yes to the question, now you're saying no. So what does your no mean? Did you make the payment or you didn't make the payment?
Whenever I would fight, payments would come out, sir. So I would have to go back and see when I just was not consistent with the payment, sir.
Objection, non-responsive.
Sustain.
Did you make payment you did not make payment on July 1, 2024 for medical support? Yes or no?
Yes, sir.
Yes, sir, you made payment?
I can't. What'd you say?
Did you make payment?
Yes. If I had a fight, then payments came out.
Objection, non-responsive after yes. So
Sustain. Hold on 1 second, counsel. Mr. Usman, if you would
Yes,
just
ma'am.
answer the question as best you
Yes.
can as he's
Yes,
asking.
ma'am.
And then if there's something that needs to be cleared up for you to explain, your attorney will do it, okay?
Okay.
Okay, go ahead.
On August 1 of 2024, you did not make payment for child support of $824 as ordered by this court. Yes or no?
No.
Okay. On August 1 of 2024, you did not make payment of $250 for medical support as ordered by this court. Yes or no?
No.
Okay. And then I'm going to take you to Exhibit 30, Exhibit 28, our Exhibit 28, which is also the, I believe the OAG also has that. Let me see if this will let me share my screen, Your Honor.
Okay.
Can you see my screen?
Yes, counsel, could you zoom in? Mr. Usman, can you see that?
Barely. I'm zooming in on my side. Yes, I can.
Okay.
All right, this is a pay record from OAG. This has already been pre-admitted. So here is July 1 of 2024. Per their record, it shows that you did not make any payment. Do you see that?
Yes.
Do you have any evidence to refute this?
The payment came out when I had a fight.
Objection not responsive.
Sustain.
You don't have any evidence as we sit here now to refute that this information is not correct. Is that true?
Yes, sir.
Okay.
Judge, I'm gonna object to the form of the question. He did pay. Like it's right here before all of us. Like his payment is due at the end of the month. He paid $1,299 on July 29th, and then he paid $250 in medical support. He did pay in July 2024.
Okay, so what is the legal objection?
I guess I'm going to object facts not in evidence.
I'm going to object to counsel testifying.
Sustain as to facts not in evidence.
Okay. So per the record, I'll start from the July 29th. So per the record, it says you made a payment of $1,549 on July 29th. Is that true?
Yes.
Okay. But you did not make a payment on July 1, 2024. Is that correct?
Correct.
And you did not make a payment for medical support as well on July 1, 2024. Is that correct?
Correct.
Okay. And then if we go to August, you didn't make a payment in August 1 of 2024 as you were ordered. Is that correct?
Correct.
And you didn't make a payment for the medical support in August of 2024 as you were ordered. Is that correct?
Correct.
Okay. Thank you. Now, we asked you for information regarding your income in August, and we asked you for information regarding your income, and you did not produce that information. Is that correct?
Incorrect. I sent you everything that I thought was for the case.
Objection not responsive after incorrect.
Sustain.
You don't have any evidence right here, right now, to show that in August of 2024, you did not have the ability to make this payment that was ordered by this court.
Would you,
Judge, I'm going to object to leading. This is direct testimony. You called him as a witness on direct.
Okay. All right.
I didn't get the objection, counsel. Hold on. What was the objection, Attorney Powell?
We're going to object leading, Judge.
Sustain. Don't
leading,
lead.
I can ask him leading question. He's an adverse witness.
He's on direct.
So, but I called him as an adverse witness. So even if I call him on direct, I can still lead him because it's adverse.
Okay, I didn't see where you called him as adverse. You just called him as your first witness.
Yes, Judge, but we're trying to get child support. We're trying to find it, prove that he's guilty of child support. So he's adverse to our pleading.
Okay. The court will allow it.
Okay. All right. So, Mr. Usman, you have not provided any information to us regarding your income in any of the ones that we're alleging that you are in violation. Is that correct?
I have provided my income and my bank statements as well as my current employment, sir.
All right. Pass the witness at this time, Judge.
Okay, counsel, you have 3 minutes and 40 seconds left. Attorney Powell, you have 9 minutes and 10 seconds. State has 10 minutes.
Okay. All right, Mr. Usman, as you were stating, when you fight, how are you employed?
I mean, I'm employed as I'm working security at an All-Star Security in Fort Lauderdale, Florida. But before I was a UFC fighter.
Okay, and when you had fights as a UFC fighter, money was coming out of your check every time you had a fight. Is that correct?
Objection leading.
Yes, sir.
Hold on.
Well, he's on cross for me.
True. Overruled.
Judge, it is his witness. He cannot lead. The rules of
Counsel, I allowed you to lead him when you didn't call him as an adverse witness. So I'm going to give him the same leeway that I gave you. Okay, you may proceed.
All right. Now, as you were stating, when you worked when you had fights, money came out of your check. Is that correct?
Yes, sir.
Okay. And the date that I recall, the July 29th payment, that was from when you had a fight. Is that correct?
objection. I'm
Yes.
leading.
Yes,
Just for the
sir.
record. Objection leading.
Okay, counsel,
I'll reframe the question.
sustain, okay, you're reading from the payment record, right?
I am.
Okay, so yeah, I think you can rephrase that question.
Okay.
Go ahead.
How did you, the payment that shows up on the payment record for July 29th, 2024, how was that payment applied?
The payment came out of my fight that I had.
Okay. And again, do you recall how much was the payment?
Roughly around 1,500.
Okay. And do you recall how much your monthly obligation is?
I think 824.
Okay. Okay, so the payment that was made, that exceeded your child support obligation, is that correct?
Yes, sir.
Okay. And how are you currently employed?
I'm working a full-time security job at All-Star Security in Fort Lauderdale, Florida.
Okay, and what is that, a W-2 job?
Yes, sir.
Okay. And so the Attorney General, they could withhold from that check?
Yes, sir.
Okay. And have you provided that information to the Attorney General's office?
Yes, sir.
Okay. Now, since this case has started, since I've been appointed to represent you, how much have you paid?
Roughly 23.
Objection relevance. This is a contempt here, and the relevant issue is: was there an order? Was that order in writing? Did he violate the order? What he has paid now is not relevant to the contempt issue before the court.
I'm arguing best interest of the child. Best interest of the child is always relevant in a family court case, isn't it?
It's it's not relevant in an enforcement matter. Sustain.
Judge, but I I mean, if the punishment is for him to go to jail today, I think it's relevant what he's paying today, like what he has right now. Like if he goes to jail, what would he like what will he lose? Or what would the children lose? They would lose the ability to benefit from the job that he currently has. So I think that the job that he would currently lose is relevant.
Okay, counsel, you may ask your next question.
All right, Mr. Usman, what what is your current method of transportation?
Right now, my car. I don't have a car right now. I'm staying with one of my teammates that me and him work at the same job. So, we basically carpool together to the job. And
Objection narrative. Objection not responsive.
Sustain as to non-responsive.
Okay.
The question was, what is your current method of transportation?
I carpool.
Okay. Have you ever owned a jet?
No, sir.
Objection relevance.
Sustain.
I think the court will see how it's relevant soon. How do you when you have fights? What would be the method of transportation?
Objection relevance.
Hold on 1 second. Counsel, what's the relevance?
Judge, they're gonna present some prejudicial evidence. I anticipate, and so I guess I'm just trying to get ahead of that.
Which exhibit are you referring to? Because remember, all the exhibits that are in evidence already.
Right. I would say it's exhibit 22, exhibit 24, exhibit 25, exhibit 26.
Okay, so your question was, when you have fights, what is your method of transportation?
That's correct, Judge.
Okay, and how is that relevant to the enforcement hearing on whether or not he's paid child support?
Okay. Well, I'm assuming they're gonna show it to make it seem as if he lives this lavish lifestyle and that he's on private jets. So I'm having my client testify that. Well, I guess his testimony is going to be his testimony, but it's presented to contradict what they're going to try to present as evidence that he flies on private jets.
Okay, sustain.
Okay. All right. Mr. Usman, do you need a passport and your license and your occupation?
Yes, I do.
Okay. Why?
Because when I do have a fight scheduled, a lot of the times all the fights are international, and I have to be able to be mobile to get to my. I have to be able to be mobile because I use a golf cart at my job, and then I have to have a license to be able to use that and work.
Okay. And you understand that one of the remedies that they're seeking today is to suspend your license and your passport.
Yes, sir.
Okay. Judge, I'll pass the witness.
All right, state.
Just very briefly, Mr. Usman, you understand that the motion for enforcement that was filed in this case was filed from November of 2024. You understand that?
Yes, ma'am.
And that you were court ordered to pay $824 a month in current child support,
Yes, ma'am.
and your medical support obligation was $250 a month.
Yes, ma'am.
And so for that time period, you understand the state, according to the payment record, which has been admitted, show your child support arrears for November 2024 were owed in a total of $36,791.84. You understand that?
Yes, ma'am.
And your medical arrears owed for that same time period were set $7,900.62.
Yes, ma'am.
Okay. And if the court does take a judgment today on your arrears, the state would request it be updated to reflect what you currently owe in child support arrears, which would include payments that have been missed since then. Do you understand that?
Yes, ma'am.
Right. And according to our payment record, as of February 1st, those arrears are now $52,555.02. Do you understand that?
Yes, ma'am.
And the medical arrears are now $12,056.37, which is what the state will request for your current judgment amounts.
Yes, ma'am.
I'll pass the witness, Judge, and I can give my time to the parties if they need it.
Okay, thank you, counsel. Just so the record is clear on the child support judgment as of February 1st, $52,055.02.
$52,555.02, Judge.
Got it. All right, and the medical is $12,056.36.
37 cents.
7. All right. Thank you, counsel.
Thank you.
All right.
Excuse me, Judge. Excuse me, Judge.
Yes, sir.
Yes, for the record too, since I've had my full-time job, I have been making my payments per what I've been making.
Hold on. You're giving me testimony. So
Okay.
you're still the witness for Attorney Chide, okay?
Oh, yes, ma'am. Okay.
Go ahead, Attorney Chide.
Okay. All right. So I'm going to pass him right now, Judge.
All right. And the state has 8 minutes and 14 seconds left. Each of you will get 4 minutes and 7 seconds.
Can I call my next witness?
Yes. Is that all the questions, Attorney Powell, that you had to?
At this time, yes, Judge. I would ask for the right to have the ability to call him if I see fit, but I'll pass him for now, Judge.
Of course. Okay. Attorney Chide, you may call your next witness.
Ms. Hillary. Okay. So you recognize you're still under oath, is that correct?
Yes.
Okay. In July, on July 1, did Mr. Usman make payment for child support or medical support?
No.
Okay. In August, or anytime in August, did he make payment for child support or medical support?
No.
And are you asking for him to be held in contempt?
Yes.
You're asking for him to be thrown in jail for not paying child support?
Yes.
You're asking for his license to be suspended and his passport to be suspended?
Yes.
And you're asking for him to also pay your attorney fees?
Yes.
But you're asking for the suspension to be basically put on hold or to not to take effect until 30 days or so that he has the ability to try to make the payment. Is that correct?
Yes.
And if he makes the payment for attorney fees and for the child support, that he be placed on probation and not have to be incarcerated. Is that correct?
Yes.
But as a condition that if he violates any court order or that he be basically put back in jail. Is that correct?
Yes.
And you believe this in the best interest of your children. Is that correct?
Yes.
And with regards to this particular hearing, you've incurred a total of approximately $16,000.20. Is that correct?
Yes.
You're happy with my services. Is that correct?
Yes.
You're asking for the courts to make him pay the attorney fees. Is that correct?
Yes.
Pass the witness at this time, Judge.
Right, Attorney Powell?
All right, Miss Markway, it's my understanding you're asking for that my client is ordered to make a payment so that he doesn't go to jail. Is that correct?
Hold on, counsel. I can't really hear your question. Mr. Mockway has background noise. Mr. Mockway, as he asks you a question, could you mute and then unmute to answer it? Thank you. Attorney Powell.
Yes.
All right, Mr. Markway, it's my understanding that you're asking that Mr. Usman is ordered to make a payment so that he doesn't go to jail, essentially.
Yes.
Okay. How much are you asking that he pays?
What he owes?
All right, I mean, I guess I'm reading your face. I heard in your conversation with your attorney, you answered yes when he asked you if he makes a payment, you're asking for him to not go to jail. Is that not correct?
A substantial payment.
Okay, a substantial payment. So are you asking the court to make that decision on what the payment is?
Yes.
Okay. All right. Now I heard your attorney also ask that you are asking that Mr. Usman pays your attorney's fees. Is that correct?
Correct.
Okay. And you have so that's this enforcement case, and also you all had a modification case. Is that correct?
Correct.
All right. And Mr. Anunobi representing you on both cases. Is that correct?
Correct.
Do you know whether or not the 16,000 is only for the enforcement, or could some of that possibly include the modification?
I know it's for the enforcement and whatever I need necessary to cooperate with the court.
All right. So you all just had a trial previously on the modification. Well, you had a trial within February of this year regarding the modification. Is that correct?
Correct.
All right. And was attorney's fees addressed during that trial?
Yes.
Okay. Is a ruling still pending? Are you still waiting for a ruling on that case?
No, I'm not sure. But no, I don't think so.
Okay. Do you know what the ruling is?
For the modification?
Objection relevance.
Counsel, what's the relevance?
Well, I mean, there's two cases pending, and the issue of attorney's fees, I think it gets kind of muddy if he represented mom on both issues. And I mean, it's possible that there's attorney's fees that's presented today that could have been it could have went to the modification is what I'm getting to.
Okay, so the exhibit that's in evidence, exhibit number 22, it is the invoice. And that particular invoice relates strictly to the enforcement action, and it dates all the way back to 2024.
Okay. All right. So, Miss Amakwe, I guess my last question. All right, Miss Amakwe, you're asking, is it your request? You're asking that Mr. Usman provides consistent support for the benefit of the children in the case. Is that correct?
Correct.
I'll pass the witness, Judge.
Okay. Anything further from your client, counsel?
No, Judge.
All right, you may call your next witness.
I'm going to call myself.
All right, go ahead.
My name is Chidi Ananobi. I'm an attorney licensed to practice law. I'm a trial lawyer. I practice primarily in three key areas: family law, business litigation, medical malpractice. I am board certified in family law. I bill at a standard rate of $5.50 an hour. We took on Ms. Amakwe's case. I'm familiar with what is reasonable and necessary for attorneys with my skill and qualification. And we presented the exhibit that's got the attorney fees, and the attorney fees consist of stuff regarding the enforcement, and things intricately related to the enforcement. And right now she's incurred fees of $16,020, and we believe that is reasonable and necessary for the enforcement. And we're asking the court to allow us to enter a judgment for that and to allow us to enforce a judgment in our own name. We're asking the court to also look at the order of enforcement, the order of commitment that has been presented as a relief, as pretty much the requested relief that the movement is seeking. We believe that what we've presented for attorney fees is reasonable and necessary, and we're asking the court to award that against the respondent, and to order him confined or find him in contempt as ordered as articulated in the proposed order.
Okay, any questions?
Yes, Judge.
Go ahead.
Okay. Mr. Ananobi. I looked at, I don't have your exhibit 22. I have a copy of your bills, but I guess I don't want to refer to the wrong dates. But I'm assuming there's an entry on your bill that says October 7th, 2025. And it says examine client's financial documents, and your client is being billed $175 for it. Like, what does your client's financial documents have to do with the enforcement?
The financial documents for the parties, and it included the information we had on whatever little information we had for Mr. Mohammed.
But it says your client's financial documents.
All the records, whether it's hers or his, we classify as our clients.
Okay. All right, and you also have an entry there that says October 14th, 2025. It says prepare filings and exhibits for trial and enforcement, and then it also says worked on SAPSR. So, SAPSR, is that the modification? Is that the enforcement?
So we worked on the enforcement. There are, counsel, as I'm sure you are aware, if the rules allow, if you're doing something that is so intricately related to another action that it's hard to delineate it, then you can choose what part you assign it to. And that was what happened in this particular case. Most of the work was related to the enforcement. There was maybe a little thing that was done to the SAPSR, and that's what you're seeing there.
Okay, on October 16th, it says it says you and a paralegal attended an exhibit conference. And it says that the paralegal, like there's 3 hours for the paralegal and there's 2.5 hours for the attorney. Why is that discrepancy in how much time the paralegal or the attorney was present for the conference?
I think I'd probably give her a break. I would reduce my time just to help her out.
All right, November 6th, 2025. There's also a mention of, I believe that was a conference. I believe that was an evidence conference, but it's my understanding that the conference was canceled. Was there an exhibit conference on November 6th, 2025?
I don't remember the exact details, sir, but I think the record speaks for itself.
Well, the issue is that your billing statement says that it's 3 entries, and it says that it says you attended the hearing for 3.5 hours, but there wasn't a hearing on November 6th. There wasn't an exhibit conference on November 6th.
Are you testifying or are you asking a question? So I'm confused.
I'm asking a question. I asked, my first question is, did you attend an exhibit conference on November 6th?
I don't remember.
But you don't remember, but you billed for it.
Okay. So if I can answer the question, if I can, I think my staff is here, but yes, I believe we attended an exhibit conference on November the 6th. Yes, I think actually, yes, we did.
So how, Judge, I asked the court to take judicial notice that the November 6th exhibit conference shows as canceled.
You on the court's record?
Yes.
Okay. The court already took judicial notice of all contents of the court's file.
So
Okay.
I think to clarify, counsel, I think this is one where we were there for a while, and I think the respondent wanted to get new counsel and was asking for more time. And so ultimately, even though we were there with the court ended up allowing, I think that was when you were actually appointed, or the circumstances that led to your appointment. But yes, we were there for even more than the time that we're showing here, if I remember correctly, because we were there till afternoon, actually. But I think we only billed her for a couple of hours, but we're on for like 3.5 hours.
All right, Judge, I'll pass the witness.
Okay. All right. Counsel, does that conclude your testimony?
That concludes my testimony, Judge.
All right. Do you rest?
And I think the court already heard everything. The order of commitment that we filed as we were asking the court.
The court has a question about that. I didn't receive a commitment order.
Oh, okay. It was filed this morning. I can email it to the court if it has not been accepted, but it was filed this morning.
Okay. Let me see. The reason I asked because it said you billed on here on your payment record, on your invoice for the commitment order back October 2nd, 2025. Is that the same commitment order?
We made several updates to it, Judge. As the case evolved, we made several updates to it, yes.
Okay.
Because this has been going on for a long time, and there's been one thing or the other, just,
Okay. All right. So you rest?
Yes, Judge.
All right. Attorney Powell, you may call your first witness.
Judge, I rest, subject to making an argument.
Okay. All right. Closing. Or Attorney Franklin, did you have anything else?
No, Judge, nothing further from the state.
All right. Attorney Chide, argument.
Your Honor, the motion for contempt is pretty clear. Did we have an order? Was it in writing? Was it violated? And was it intentional? And so here we have, and once we make our case, she's got the burden to now try to show either inability to pay, which is really, I guess, what they're trying to do. But inability to pay legally is a very technical defense. You've got to show inability for every particular instance, and you have the burden to show that. So the question before the court is, was there a clear order? Yes. The evidence showed that. Did he violate the order? Yes. The evidence showed that. Did he have the ability to pay the order? He has not raised that defense in a legally cognizable way. And so based on law and based on what the court heard, he is to be found in contempt. The relief that movement is seeking for, movement is entitled to it. We're asking the court to hold him in contempt. and to basically move on the relief that she's seeking. She is even being kind and saying, hey, let's pretty much suspend his confinement and give him 30 days to make the payments, which include the attorney fees and what he owes. And so that way it's almost in his own hands. And so this is, he's owing over $60,000 cumulative for 2 kids, and since 2021. That is outrageous. And so, and it's really an affront on this court's authority. And so we're asking the court to hold him in contempt to move on the relief that she has sought. Thank you.
You're welcome. Okay, Attorney Powell?
Yes, Judge, thank you. Judge, in proving up that case, they proved up 2 dates. They proved up July of 24 and August of 24. And even though a court order says that your payment, you have to make your payment July 1, 2024, and every date thereafter, that doesn't mean you pay the date of July 1. And if you don't pay on July 1, that you'll be found in contempt. Or you have until the end of every month to make your full payment. And in the date that was proved up on the pay record, it showed that my client paid close to $1,600 in July of 24. So he can't be found in contempt for that date. And again, we're talking about 2 dates. They attempted to prove up 2 dates, July of 24 and August of 24. Again, 2 dates. And one of those dates, the pay record and the evidence showed that he actually paid $1,600 on one of the alleged violations. And $1,600 when your current child support obligation at that time, it was $824. $824 for child support and $250 for medical. There's an element of the law, an element of family law and enforcement of substantial compliance. I mean, for 1 month, obviously he exceeded what he was supposed to pay. And again, they pled 2 months. Well, they are alleging and seeking to find my client in contempt for failure to pay for 2 months. And in one of those months, he actually exceeded the obligation. So I don't think that it's in the best interest of the children that he has a jail sentence. And we're talking about 2 months. And one of the months, he paid over what he was supposed to pay. If they would have proved up more dates, I think my argument would be different. But again, I mean, my client is employed. As money is the same way money is coming out of his check as a fighter, money could be coming out of his check for his security work. I think that yes. I mean, it's not my argument that he should get away with not paying. The Attorney General has many different mechanisms for enforcing child support. And in the state of Texas, there are many different mechanisms for enforcing child support. And the answer and the fix isn't always put him in jail. The easiest thing you could do is you take the money from him. And I mean, that's something that's going on actually in this country. There's an issue with people paying student loans. And what is this administration doing? This administration is saying, well, we're going to start taking money out of people's checks to address that issue. That's an enforcement. So my client is asking that the court does what's in the best interest of the children, and that's allow him to continue to work. So please don't suspend his license and his passport, and let him work and let money go to the support of the children. That's my request, guys. My request. And I would just again like to emphasize that just because your payment is due on the first of the month, you have the whole month to make the full payment. And Miss Franklin is well aware of that. That's all I have, Judge.
Okay. Attorney Franklin, closing.
Yes, Judge. So the state's position pertaining specifically to the judgment on the arrears, Judge, if a judgment is taken for the child support arrears, again, as of February 1st, 2026, we will request the $52,555.02. Taking into account the interest that will be accruing on that, we would request it be paid at $313 a month. As far as the medical arrears, again, that judgment is $12,056.37. And taking into account the interest on that one, we will request a payout of $111 a month. And that's all from the state.
Thank you. Let me go back to the record for something. Okay. So we're back on the record. The court, I needed to go back through the record briefly to see exactly where we were. So the court is going to find that Mr. Usman did violate the order. As for the August, what is that exact date? I just have the year on the record.
August 1, 2024, Judge.
August 1 of 2024. There is no violation on the July 1st, 2024, because technically, according to the statute, he has the month to pay it. So he wouldn't be held in contempt for that one, but he would, the court does find that he violated the August 1st, 2024 date, and he's held in contempt for that day. The court is not going to place Mr. Usman in jail. The court is going to probate the sentence and allow him to become current on his child support. Now, mom did make a request for the court to determine what a substantial payment would be. Mr. Usman, you, as of February 1st, you're in arrears of child support of $52,555.02 and medical support of $12,056.37. How much, I'll give you the opportunity to tell me, how much are you able to make to put a dent in both of those?
Your Honor, I'm just being realistic. I also
Be honest with me. I want you to be honest.
Yes, ma'am. I filed a motion to modify my child support to match my current income and what I'm making, so I can be able to pay. You know, I got pushed back on child support, and with this full-time job I got, I'm bringing in between $500-600 a week, and with the security job, and I've been making all my payments since I got the job, as I have, you know, with the child support, and I tried to put a $1,500.
Hold on. One second. Let me stop you right there, because I don't want you to get confused about what this is today. You filed a motion to modify your current child support obligation, okay? The enforcement today is for the order that's currently in place. So you're still going to be on the hook for that. So my question is, of what I just said to you that you are ordered to pay, how much realistically are you able to make?
A month?
Just not in a month, because I haven't gotten a recommendation from the state, because the state has to give me a recommendation on what your payment amount should be for the arrearages on top of what you pay for child support a month. You understand that part?
Yes, ma'am. Okay,
so this would be what you would be paying to put a dent in those amounts. So let me give you an example. If you say, Judge, I can do $5,000, I can put 2,500 towards child support and another 2,500 towards medical. That's an example of what I mean. If you can do something bigger than that, if you can borrow money from somebody to put a dent on those judgments, that's what I mean by a substantial payment.
Okay, yeah,
Judge, if I may, it might help him if you like tell him what time frame you're looking at.
Well, I haven't gotten there yet. I want him
Okay,
to
okay,
give realistically what he can pay.
all right, okay, I'll be quiet.
Yeah.
I'm just realistically being, if I can ask my family, call around, I'm realistically thinking 2,500. I could possibly get up 2,500, 3,000. Just me asking family members and people to be able to help me with the situation. That's just me being honest with you, Judge.
Okay. Is it possible, and I'm just asking, is it possible for you to borrow 5,000? And the reason I'm asking that, Mr. Usman, is because even with a $3,000 payment, interest hits this amount every single month. So
Yeah.
even if you pay the 3,000, it's going to get eaten up in the interest on both of those judgments. So
Yes, ma'am.
the larger, right? The larger the payment, the faster you're able to get it down. So, are you able to borrow 5,000?
I'll surely try. Yes, ma'am.
Okay. So, how much time will you need to pay that substantial amount?
I would say 30 days
30 days? Okay.
to be able to just call around and see who I could muster up, sir. I mean, ma'am.
Let's do this. How about I give you 45 days?
That's even better to be able to get that together.
Yes. Let's do that. What day would that put me out if anybody has their calendar? Would that put me the week of March 14th? I'm sorry, not March, April 14th.
Believe so.
Okay, let's do April the 13th, okay? Mr. Usman, I'm giving you to April the 13th to come up with the $5,000. That's going to be your substantial payment right now, okay? And this is in addition to what you have to pay in child support. Attorney Franklin, what is the recommendation for the payout amount on the child support and medical support judgment?
So just the child support payout recommendation was $313 a month, and the medical was $110 a month.
All right. So the court is going to accept their recommendation. Mr. Usman, that recommendation covers the interest too, okay? So just so we're clear, that's on top of what you're going to have to pay monthly in child support and the $5,000 due by April the 13th. I'm going to place you on community supervision for a period of 1 year.
All right, okay. You guys are supposed to come in the morning.
Okay.
Okay.
Mr. Usman, can you hear me?
Yes, ma'am. I was just hearing a lot of background noise.
Okay, I muted. Sorry about that. That was attorney Chide. So what was I saying? Yeah, you understand all of that, right?
So what's that, like probation?
Yes, probation. So that means you'll have to report to a community supervision officer, and you're out of state. So it'll more than likely be via Zoom or by telephone. The probation officer is located here in this building, Mr. Shelton Brown. He will give you all of the directives in terms of reporting. And your main condition of probation is to make sure that you pay your child support, okay?
Mm-hmm.
All right. And then in terms of the attorney's fees, if the court finds that you violated the order and you are held in contempt, it's not discretionary. The law says I shall order you to pay attorney's fees, and that is enforceable as a judgment for child support. So the court is going to order you pay attorney's fees based on the exhibit that is in front of the court. One that I was. Now, with the exhibit in front of the court, I asked about the, what do you call it? The commitment order, but I haven't seen a commitment order. So that is included in this amount. So the court is going to award attorney's fees in the amount of $7,485. Counsel, I didn't ask you this. Were you looking for payment through how child support would come out through a withholding order, or were you looking for a judgment?
What we pled for was for a judgment. So
Okay.
But we wanted we wanted it to also be enforceable by any means, enforceable for child support.
Okay. Let me just make sure this.
Your Honor?
Okay, hold on one second.
Yes,
So-
ma'am.
Okay, so what I'm reading is a judgment. Respondent should be ordered to pay reasonable attorney's fees, expenses, and costs, and a judgment should be rendered in favor of attorney and against respondent and be ordered paid directly to the undersigned attorney who may enforce the judgment in the attorney's own name. Petitioner requests post-judgment interest as allowed by law.
Are you reading the proposed commitment order?
No, I don't have the commitment order. What I'm reading is the motion for enforcement.
Okay.
Okay, so the court is going to award attorney's fees as a judgment in the amount of $7,485. Attorney Usman, that is to be paid directly to oh, I'm drawing a blank.
Attorney Chidi Ananobi.
Yes, thank you. It is to be paid directly to him. He is able to enforce it as he sees fit. Okay. So any remedy at law to enforce a judgment, like attaching liens and all those things, he is able to do that. So you have that judgment on top of the child support that you're ordered to pay. Now you had a question.
Yeah, I was with Your Honor, like with my current job, and it's being a full-time job, I don't have the present ability to pay that right now. You know, I'm with what I'm making, roughly $500 to $600 going towards the child support and just my basic living at this current moment. I just don't have the ability to be able to pay that right now.
Mr. Usman, me and you will talk about it. We're gonna
Okay.
talk about it.
Okay.
And I just want to say this, Mr. Usman. When it comes to child support, it's an obligation, just like any other obligation. So you may, I don't know what your schedule looks like. It may have to be a situation where you are working multiple jobs. You may have to do 2 or 3 jobs to satisfy whatever it is your child support is. And what I also want to tell you is that as long as you're paying something, right? You need to just pay something monthly. You can't go without paying anything. Pay
Yes,
something
ma'am.
monthly. So then at least the payment record will show that you are attempting to pay something. Does that make
Yes.
sense?
Yes, ma'am.
Okay. All right. I think that's everything for the record. Oh, we're going to do a report back date. So I have you set for April the 13th of 26 for that payment. I'll do a reset day somewhere after that. How does everyone's schedule look for Monday, April 20?
And while we're looking that up, Judge, please, I missed that part. How long is the probation? What is the sentence that is being probated for? How long?
He's on probation for 12 months, 1 year.
Okay. And what is the sentence that is being probated? Is it
180.
180? Okay. Thank you, Judge.
You're welcome. All right, so I
April,
have, oh, go ahead.
yeah, April 20 works for me.
Does April 20 work for everyone?
Yes, Judge.
If my assistant will be permitted to speak on my behalf, I'm having computer issues.
Okay.
Ms. Necker, does April 20 work for us, please?
Yes, he does.
Thank you, ma'am. Thank you.
All right. And I'm pretty sure I know the answer to this question, but is it going to be via Zoom or in person?
Zoom works for us, Judge.
Okay.
Yeah, that works, Judge.
All right.
Same. Zoom works.
Okay. And I'm going to make it at 10 o'clock a.m. All right. Soon as it gets on the computer, I'll order you to reappear, Mr. Usman. Okay. So, Mr. Usman, I'm ordering you to reappear on Monday, April 20th, 2026. Here on the same Zoom code that you used this morning for a report back hearing. The Zoom code is 688-044-0164. Your failure to appear may result in a capious warrant being issued for your arrest. Do you understand those instructions?
Yes, ma'am.
Do you have any questions for me about those instructions?
No, ma'am.
All right. Counsel, how much time do you need to draft the order?
I think a week is fine, Judge.
All right. So I can put you on the entry docket. Hold on, let me switch calendars here. I can put you on the entry docket for March 6th.
Okay. And if the other counsel sign, would we still need to show up?
No, you won't. Thank you for asking. If everyone signs the order, just send an email with everyone on it to my coordinator and we'll remove that date and I'll just see you all back in April.
Okay. Thank you, Judge.
You're welcome. Thank you all.
Thank you.
Thank you.
Yes, you're excused.
Thank you.
Thank you, Judge.
You're welcome.